Hello everyone. In the last presentation, the rules pertaining to defamation have been dealt with. In this presentation, the defenses that can be pleaded in an action for defamation and the remedies available for the tort will be dealt with. We have seen that in order to succeed in an action for defamation, the plaintiff must prove that the statement was false and defamatory. It referred to the plaintiff and that it was published by the defendant. When the plaintiff brings an action against the defendant for a particular tort, the defendant may avoid his liability by taking the plea of some defense. There are some general defenses like consent which can be taken for trespass, defamation, false imprisonment or any other tort. But there are certain specific defenses which are available to some particular torts. Defamation is such a tort for which there are certain specific defenses. The defenses available to the tort of defamation under common law were justification or truth, fair comment, privilege, and consent. Truth published with good motive and for justifiable ends is the first defense. Here, the charges laid must be true in fact and in substance. Truth is therefore a complete answer to a civil action for defamation. However, in criminal cases, truth is no defense unless it is for public good. Coming to the defense of fair comment, a fair comment on a subject fairly open to public discussion will not amount to defamation, and if loss ensues as a result of legitimate criticism, it is damnum sine injuria. However, the way of exercising this freedom must have some social value. The defense of fair and bona fide comment is only applicable to expressions of opinion as distinct from assertion of facts. The defense of fair comment will be available only when the comment is fair and bona fide and the subject matter of comment must be of public interest. Matters of public interest include affairs of state, public acts of ministers and officers of state, administration of justice, public institution and local authorities, theatres, concerts and other public entertainments, and other appeals to the public. Malice destroys the defense, though it is for the plaintiff to prove it. A privilege is always special, exceptional, and artificial. It can be enjoyed on certain special conditions. It is a peculiar benefit, favor, or advantage. A statement is said to be privileged when it is made in such circumstances that it does not render the person making it liable to proceedings for slander or libel, although it would have that effect in the absence of those circumstances. When therefore a person stands in such a relation to those circumstances and facts of the case that the law recognizes the right of free speech as more important than the plaintiff's right to reputation, he is said to have a privileged occasion and he is justified in speaking or writing even that which would have been slanderous or libelous in case of any other person. A privilege is of two kinds, absolute privilege and qualified privilege. In absolute privilege, the law provides special protection to statements made on certain occasions because of compelling considerations of public policy, and so the statements made on such occasions cannot be made the subject matter of litigation in courts of law, even though they may be defamatory, and no action for defamation will lie in respect of them. So far as the qualified privilege is concerned, a communication is said to be so privileged if it is made by a person in discharge of some duty, legal, moral, or social, whether public or private, or to protect his own interest or the interest of any person. Communications fairly warranted by any reasonable occasion or exigency are also protected for common convenience and for the welfare of the society. Now, what are the points of distinction between absolute and qualified privilege? In absolute privilege, it is the occasion which is privileged, and when once the nature of the occasion is shown, it follows as a necessary inference that every communication on that occasion is protected. In qualified privilege, the occasion is not privileged until the defendant has shown how that occasion was used. In absolute privilege, the defendant gets absolute exemption from liability, but in qualified privilege, he gets a conditional exemption. In absolute privilege, even though there is malice on the part of the defendant, he is exempted from liability, whereas in qualified privilege, he is exempted only when there is no malice on his part. In absolute privilege, statements are protected in all circumstances, irrespective of the presence of good or bad motives. in qualified privilege even after a case of qualified privilege has been established by the defendant. The plaintiff may prove in reply improper or evil motive on the part of the defendant, in which case the defense of qualified privilege vanishes and the plaintiff succeeds. In absolute privilege as well as in qualified privilege, the defendant has to prove the plea of privilege, but with this difference that in the former, the defense is absolute and irrebuttable by plaintiff, whereas in the latter, the defense is not absolute but rebuttable by the plaintiff. Because of its drastic effect in excluding all opportunity for justifying a slandered reputation, absolute immunity is rarely granted and only as an aid to give the efficient functioning of our governmental institutions, legislative, executive, and judicial. Accordingly, absolute privilege is limited to the following occasions: 1. Proceedings of Parliament. 2. Newspaper reports of parliamentary proceedings. 3. Judicial proceedings. 4. Reports of judicial proceedings. 5. Reports regarding affairs of state. And 6. Proceedings of military and naval tribunals and authorities. A privileged occasion in reference to qualified privilege is an occasion where the person who makes a communication has an interest or a duty, legal, social, or moral, to make it to the person to whom it is made, and the person to whom it is made has a corresponding interest or duty to receive it. This reciprocity is essential. The privilege is thus limited to the necessities of the situation and carries with it an obligation to be fair. The important elements that go to make the defense of qualified privilege available are that there must be an occasion for making a statement and the statement must be made without malice. The following matters are covered under qualified privilege. 1. Fair reports of parliamentary proceedings, judicial proceedings, public meetings and meetings of public bodies. And 2. Communications made to persons in public position for public good, in self-defense, in discharge of duty and for protection of common interest. Consent negatives defamation. As observed by Salmond, when plaintiff invites the speaker to repeat the defamatory words before witnesses, the defense of express or implied consent to the publication of the defamatory matter arises. What are the changes so far as the English defamation law is concerned? In England, the law pertaining to defamation, especially the defenses that can be pleaded by the defendant, has been undergoing changes right from 1952, when an attempt was made to codify a part of the common law on defamation, which was further amended and updated in 1996 and recently in 2013. The aim of these acts, by and large, was to strike a balance between two competing interests, the right to reputation and the freedom of speech and expression. The 2013 Act was also intended to remove the difficulties that arose in dealing with online defamation by making it easier for the defamation law to be enforced online without unreasonably restricting one's freedom of speech. Coming to the changes that have been brought about by these acts, Section 4 of the Defamation Act 1952 provided a procedure to avoid liability in case of unintentional defamations if it is proved that the publisher did not intend to publish them of and concerning that other person and did not know of circumstances by virtue of which they might be understood to refer to him, or that the words were not defamatory on the face of them and the publisher did not know of the circumstances by virtue of which they might be understood to be defamatory of that other person, and in either case the publisher exercised all reasonable care in relation to the publication. If an innocent publisher makes an offer of amends, that is a suitable correction and an apt apology as soon as possible, that will save him from the liability. Now, so far as the changes brought about by the Defamation Act 1996 are concerned, Section 1 of the Act states that in defamation proceedings, a person has a defense if he shows that he was not the author, editor, or publisher of the statement complained of, that he took reasonable care in relation to its publication, and that he did not know and had no reason to believe that what he did caused or contributed to the publication of a defamatory statement. Section 2 of the Act provided for offer to make amends, which is an offer to make suitable correction of the statement complained of and a sufficient apology to the aggrieved party, to publish the correction and apology, and to pay costs and compensation as agreed to by the aggrieved party. If this offer is accepted, the plaintiff may not bring or continue the defamation proceedings in respect of the publication concerned against the person making the offer. If the party does not agree, the party making the offer may make the correction and apology by a statement in open court in terms approved by the court. The fact that the offer was made is a defense to defamation proceedings unless the person making the offer knows that the statement refers to the plaintiff and it is false and defamatory. Reynolds versus Times Newspaper Limited was a case which recognized a defense called Reynolds defense. The question in this case was whether the defense of qualified privilege could be extended to cover the mass media. The court held that when it was clear that the journalist had a duty to publish an allegation, even if it turned out to be wrong, the defense of qualified privilege would be available. When the defendant pleads Reynolds defense, a court has to investigate the conduct of the journalist and the content of the publication. Thus, by and large, the law sought to protect the reputation of individuals, but this hindered free speech and protected powerful people from scrutiny. It was felt that the law of defamation placed too much restriction upon the ability to express oneself. The courts attempted to strike a balance between the two competing interests. One such example being Reynolds' case. Development of internet also made it difficult to offer protection against online defamation. This led to the enactment of the Defamation Act 2013 with an intent to reform the law of defamation so as to strike a balance between protection of freedom of speech and right to reputation by codifying the existing common law principles, making it clear when defamation action can be maintained. Defamation Act 2013 abolished the defenses of justification and fair comment and introduced the defenses of substantial truth and honest opinion. The common law Reynolds defense was replaced by statutory public interest defense. Section 1 of the Act introduced a serious harm test for all defamation claims, according to which a statement will not be considered defamatory unless it is shown that its publication would cause serious harm to the reputation of the individual. Section 2 introduces the defense of substantial truth. According to this section, if the defendant can demonstrate that the statement made is substantially true, then he will be capable of relying on this defense, thereby ensuring protection to freedom of speech by allowing the statements of truth to be made. Section 3 provides a defense of honest opinion. The defendant can rely on this defense if he can show that the statement made was an honestly held opinion. Section 4 introduces a statutory public interest defense which allows for statements to be made that are said to be a matter of public interest provided the maker of the statement believed it to be the case. According to Section 5 of the Act, where an action for defamation is brought against the operator of a website in respect of a statement posted on the website, it is a defense for the operator to show that it was not the operator who posted the statement on the website. According to Section 6, publication of a peer-reviewed statement in a scientific or academic journal, whether in electronic form or otherwise, is privileged. Thus, the Act codifies the existing common law rules and principles, thereby making it easy to determine when a defamation action can be maintained. Remedies for defamation are injunction and damages. Imminent threat to reputation may warrant an injunction to prevent the publication of the defamatory material. Damages awarded may be general or special. It may be nominal, contemptuous, or exemplary based on the facts and circumstances of the case. So far as India is concerned, Part 3 of the Constitution of India incorporates certain fundamental rights, and right to freedom of speech and expression under Article 19(1) is one of the several freedoms guaranteed to in it. Freedom of speech and expression means the right to express one's convictions and opinions freely by word of mouth, writing, printing, picture, or in any other manner addressed to the eyes or ears. This protection to freedom of speech and expression is, however, subject to various reasonable restrictions enlisted under Article 19(2), and defamation is one of them. These restrictions stand on the universal principle that no right is absolute, and right to freedom of speech and expression is no exception. Regarding defamation, there is no statutory law of defamation in India except what is contained in section 356 of chapter 19 of Bharatiya Nyaya Sanhita, which imposes criminal liability for defamation. As for civil liability for defamation, the common law of England was the prevalent law before the Constitution came into force, and it is declared as the law in force under Article 372 of the Indian Constitution. Many aspects of tort law have not been codified yet, and for a civil action for defamation for which there is no codified law in India, a common law right can be taken recourse to under Section 9 of the Civil Procedure Code. As to the remedies available to the person defamed, he may either proceed by filing a criminal complaint or may file a civil suit for damages. An injunction under Section 37 and Section 39 of the Specific Relief Act 1963 may be obtained to restrain the defamatory publication. This, in brief, is about the defenses and remedies available for defamation, which is a tort affecting reputation. Thank you.